Good evening and welcome, everyone. My name is Victoria Fisher, and I'm the Program Assistant here at the Institute for Intellectual Property and Social Justice. Thank you all for joining us for tonight's webinar, which is the fifth webinar in this school year's IP for the People Academy series. This series is a free, digital, open access academy designed for and marketed to creators, inventors, and entrepreneurs from communities of color who have historically and continually been locked out of receiving key knowledge and resources related to protecting and profiting from their ideas. In this series, we offer easy to digest and engaging talks on IP rights and navigating the IP system, highlighting tips and resources via live webinars, which are saved as an on-demand video series on our YouTube page. Tonight's webinar is directed to providing information for entrepreneurs on what to expect when filing patent and trademark applications with the United States Patent and Trademark Office. We're glad you're here for tonight's session, and we hope you'll join us for future sessions. Please sign up for our newsletter to ensure that you're notified of future events. Now, I'll turn the program over to our session instructor, Victor Wang.
Hello, everyone. My name is Victor Wang. I am the director of the Patent Diversity Project and the Tech Startups Clinic at Cardozo School of Law, and it is an absolute pleasure to be here today. Today we'll be discussing how to protect your patent and trademark. Usually a session like this, I will be speaking for 2 hours on patents only, but today we are definitely going to condense to the most important points, in my opinion, and discuss both patents and trademarks for your pleasure. In today's agenda, we will be discussing, starting off with intellectual property overview. It would be good for us to understand and have a framework of intellectual property and then place trademark and patents within that framework, so you may understand as entrepreneurs what you will need to protect moving forward. And then we will discuss trademark. It will be a 101 type session, patent 101, and lastly, about 10 to 15 minutes of Q&A. Let's start with an intellectual property overview. So, what is intellectual property? You may be walking down the street, humming a song that just comes to you. That can be intellectual property. You are finding a problem with the plumbing and you have created a brand new widget that solves this problem. That could be intellectual property because it is a creation of the mind. Whatever that it is that you have created, it would be in your intellectual property. From your perspective, for entrepreneurs, it is important for you to identify when you have generated and created intellectual property. From your perspective, the first step is generally identifying your product. If you wish to put a product on sale or provide a service for profit, you will want to identify this product as something that may be unique in the marketplace. And you want to identify the type of intellectual property protection that is available for your product. For some of the questions that you may ask yourself will be, have I created a literary work subject to copyright, like the tune that we were just speaking about? Have I created something that may be copyrightable? Have I created an invention that is protectable by patent? Inventions are protected by patent. Have I created a brand that is protected by trademark? A logo, a short phrase that may be protected by trademark. And lastly, should I protect my information by trade secret? Trade secret is another type of intellectual property. And after you have identified the product and the type of intellectual property protection, you may be interested in the how. How do I protect this product? And how do I protect the brand? And there are several questions that you may be asking, such as, what is the process that I may go about in order to protect this product? And what are some of the pitfalls that I may want to avoid? For this particular webinar, we will tackle some of these questions, which will be the patent question, the trademark question, and the process and the pitfalls involving each of these intellectual property protection schemes. All right. So let's dive right in. A trademark 101. Question, what is a trademark? Well, the real definition, or that is, I believe, more digestible, is it could be any word, phrase, slogan, symbol, design, or some combination. And I'm sure you all have encountered trademarks in your entire lives. And these trademarks identify the source of a good or service. Let's say, for example, we will use Coca-Cola as an example. The Coca-Cola mark can be used to protect Coca-Cola as a good, as a physical product. One may drink the product, get a six-pack, excellent, right? It's a fine beverage. And Coca-Cola, the mark can also be representing a service. The moment you seek the Coca-Cola brand, you know what kind of product you're obtaining, and you know that you can obtain the service of, for example, delivering Coca-Cola products to your store, your home, bodega, etc. So the trademark of Coca-Cola encompasses both goods and service. There is another item that's called trade dress, and that protects the look and feel of an item. For example, if you saw a Coca-Cola bottle or just the silhouette of the bottle, you know that it is from this particular brand. We're not going to be discussing trade dress today. We're going to focus on trademark for goods and services. But I wanted to make a note that this is a shorter session, but the story behind trademark is, of course, more and more complicated and nuanced. There are many different types of marks. For example, just a picture here, there are 3 types of marks involved right here. There's the word mark, such as Nike. There's the logo, such as swoosh. And then there's the phrase and the slogan, just do it. All of these would be able to indicate to the consumer the source of the good, the quality associated with it, right? The brand behind it. There may be other types of mark. Images, any type of picture, for example, the Energizer Bunny, that indicates the source of the good. It is a brand of battery. As long as this image connects you with the source of good and service, that is a trademark. Although, of course, there are some more interesting ones. For example, decor. If a decor can link the consumer's mind to a goods and service, then it can be a trademark. For example, this particular decor is a mark consists of goat on a roof of grass. The dotted lines and drawings are intended to indicate the location of the mark. All right. So if someone looks at this type of decor, they will immediately link to Al Johnson's Swedish restaurant, right? This type of mark. And of course, there are even more nuanced marks. For example, colors. All right. The colors, the one on the left, Tiffany blue, one in the middle, T-Mobile pink, one on the right, royal brown for UPS. So colors may be able to indicate the brand of the company, and the source of the good. Lastly, and certainly not least, sounds may be able to indicate the source of the good as well. You may all imagine the lion's roar, and the moment you hear that lion's roar, you know there's a movie coming, and the type of movie may be, right? That's the source of the good from that production company. So these are different types of marks, and hopefully this helps you identify the type of the intellectual property associated with your product. Type of marks. Let's go ahead and do an exercise. If you look at a Coca-Cola can, how many trademarks do you think is associated with a Coca-Cola can? There are quite a number of trademarks associated with it. And this is an exercise to help you broaden your mind and think about the possible protection that can come with your product. Take 10 seconds. Think about the number of trademarks that may be involved here. Thought of a number? All right. Let's take a look if you are about right, shall we? There are a number of trademarks that could be involved in a simple Coca-Cola can. The wording, Coca-Cola, the different font that is Coca-Cola that is stylized may be protected by trademark. Different types of fonts involved. There is the ribbon on the Coca-Cola can that may be protected, because if you have a can with just that type of ribbon, a consumer may connect this design and can and immediately think of, I know this brand, I know the good. So a brand, an image that is connected to a brand is extraordinarily powerful. So that if you are producing a good and a service, I highly recommend that you think about different ways of protecting your brand and protecting your intellectual property. If there is something unique, if there is something that will connect your brand to the image, to the slogan, to a logo, to a sound, that might be extraordinarily helpful. This is a moment of expanding your mind. And this, of course, will be a moment where I pause and take questions, but we're going to reserve the Q&A for later. We'll reserve that the questions for the last 10 to 15 minutes. This is an exercise in identifying the trademark. Now let's proceed to the act of trademark prosecution. Trademark prosecution is the process of obtaining a trademark. And just a side note, patent prosecution will be the process of obtaining a patent. So this will be trademark prosecution, and it occurs at the USPTO, the United States Patent and Trademark Office, a wonderful place located in Alexandria, Virginia. Feel free to take a visit. They have a wonderful little museum in there that a lot of inventors and entrepreneurs like visiting. Okay? That is trademark prosecution at the USPTO. Now, what is it going to be like? What is that process like? That process consists of, and this is a very simplified way of showcasing the process. Number one, after you have gone through the exercise of identifying the trademark, you have decided to then file a trademark application. So step one. Number two, the USPTO examiner will take your application and review it. And the USPTO will often issue what is called an office action. And this is basically a communication from the USPTO indicating whether there are any issues with your application, whether your trademark has been rejected or allowed. And you may respond to this letter and address any concerns or issues that the examiner may have. Once you have negotiated with the USPTO, so that both parties agree, you may then register the mark when the examiner decides to allow or grant the trademark application. After you have registered the mark, you must pay and maintain the trademark registration. The maintenance is a fee plus constant usage of the mark in commerce. And that would be trademark prosecution in a nutshell. Excuse me. Now, this is, of course, a very simplified way of looking at prosecution. It does get a little bit more complex, and that's why often people go to law clinics or hire trademark attorneys to navigate the USPTO and the prosecution process. What we're focusing here today is going to be the section where after you have filed the trademark application and you negotiate with the USPTO examiner attorney into hopefully allowing your trademark. There are a couple of key items that I would like for you, the entrepreneur, to be aware of when negotiating and discussing your trademark application with the examiner. And hopefully these are some of the things that you actually have already addressed before even filing your application. And these are some of the key issues. Number one, filing basis. Number two, likelihood of confusion. And number three, the strength of your mark. So let's first discuss filing basis. A trademark application must be based on either a current use of the mark in commerce or an intent to use the mark in commerce in the future. What does this mean? What does this mean? Essentially, what it means is, let's say, for example, you are attempting to sell a product, to sell a crochet piece on Etsy, for example. If you have a brand name, that brand name and the trademark application must be related to a product that you're already selling or that is coming soon. If your trademark is already, you are currently using the trademark and you are selling the product, you may simply supply that example to the USPTO, and that will fulfill the filing basis requirement. But if you have not started selling your product or providing the related service, and you are merely saying, oh, I am going to start this business soon, but I want to lock down the trademark first, that is perfectly fine, but you must subsequently submit to the USPTO an example of your product in commerce. And one way of looking at it is this. You have a product that you are either selling or that is coming soon, but you must provide an example of the product being sold in order to have a full registration of your trademark. And that's the filing basis. The USPTO will allow you to submit an application even though you have not used that mark in commerce. That is perfectly fine, but please do note that and you must submit the example for full registration. Okay, that is the filing basis requirement. Two, likelihood of confusion. The most common reason for an examiner to refuse your trademark registration is a likelihood of confusion between your mark and a mark that has already been registered. What does this mean? Let's take a look. These are the examples provided by the USPTO, which I believe to be perfectly sound and to be used for our purposes. Let's say, for example, your mark is T Marquee, and there is an already existing registered trademark called T Marquee. They sound the same, and the examiner may be able to issue such a refusal to register your trademark application because there already exists a conflicting mark. So you as the entrepreneur may need to do a little bit of digging and to consider if there are any existing marks that sounds like your the mark that you wish to use. So sounds like. Another type of likelihood of confusion, appearance. It appears similar. T Marquee with bold font versus T Marquee having a completely different font. Think about this likelihood of confusion. A consumer could certainly look at the conflicting mark or look at your mark and conflict it with the already existing mark. And that's why the USPTO is likely to refuse that trademark application. Meaning, lupo is Italian for wolf. If the mark wolf has already been registered, then the USPTO is likely to reject your mark that is lupo, Italian for wolf, because they have the same meaning. Another, a commercial impression. If a trademark conveys a similar general meaning and kind of produce the same mental reaction in the consumer, then the USPTO is likely to issue a letter of refusal. For example, an existing mark called City Girl, while your mark is City Woman. That would create a likelihood of confusion due to a similar commercial impression. Now, these are, of course, they're similar and they're examples. These are similar sounding, similar in appearance, meaning, and commercial impression. But the product itself must also be related. For example, if we go back to the City Woman and City Girl comparison, if one is selling plumbing services and another selling electronics, they will not be considered to be related enough to cause commercial confusion. So it does depend on if if the product that you are offering is in the same related goods and service as another existing mark. For example, if a similar sounding mark is in mortgage lending services and your service that you want to provide with the same mark is in banking services, then that would certainly be a matter of confusion. And you would face a rejection from the USPTO. So this kind of analysis is something that you should do. You should certainly consider and conduct what is called a trademark search, trademark analysis, to determine what's the likelihood of you obtaining a trademark at the USPTO in view of the existing marks. Okay, so this is the likelihood of confusion. Next, the strength of your mark. If, for example, you want to sell shoes and you think of the mark or you have created this mark, Adidas. Adidas has no meaning behind it. It is a very fanciful word, and consumer will look at it and not have any base understanding or connection, and in which to confuse them, right? Then this mark would be considered strong. Adidas is a strong mark because it is, you know, it will easily allow you to prevent a third party from using the mark. But let's say you go to the other spectrum, which is a weak mark, a generic mark. Let's say if you are a carpet cleaning company and you want to protect the mark, the carpet cleaning company, the mark is considered so weak that it is not going to be identifying the goods, uniquely identifying the good and service that point to your company rather than another carpet cleaning company. So in this case, the generic type, the weak mark, will be rejected by the USPTO, will be refused, and you will face some likely refusal if your mark is descriptive. And this is where an attorney might be able to assist you with in order to determine whether the mark that you want is either descriptive or generic, so that you can rebrand or think of another word, think of another logo, so that you can save your money. So front load the work, the trademark identification and search work, so that you do not need to negotiate with the USPTO as to whether your mark should be allowed or not. So these are the three big pieces that you should concern yourself with should you be attempting to register a trademark. And of course, everyone would love to have their mark registered among the big brands. But we do want to note one other thing, which is these little symbols that's next to these the logos, the R, the TM, sometimes the SM, if you see it. I wanted to let you know of what they mean. R with a circle means that that trademark has been registered at the USPTO. A TM would be a trademark for goods, and SM is a trademark for services, and both are currently unregistered at the USPTO, but they may still have certain rights. It may be that the product is currently claiming a different level of trademark rights. So a lot of people prefer the registered trademark, that will be the R with a circle, and they will use that mark in order to inform people, hey, don't infringe my brand. I'm registered at the USPTO. And this is Trademark 101. Now, let's discuss patents. Patent 101. First question, of course, what is a patent? What kind of rights do you have if you obtain a patent? Some people might say monopoly. Some people say right to make the product. I would like to clearly indicate to you that the right that you have obtained with a patent is called the right to exclude. You have specifically the right to exclude others from making, using, offering for sale, or selling the invention in the United States, or importing the invention into the United States. So a patent right is the right to exclude. What does that mean? Let's go with an example. This is one of my favorite patents of all time, the super soaker. And the right to exclude related to the super soaker is different than the another type of right. Allow me to illustrate. If you are the patent holder, and now you have obtained this patent, does that mean you can now make that product? I would say most people would say, yes, I have a patent. Of course I can go ahead and make this product, but not necessarily. The right to exclude is different from the right to make. Why is it different? Because even though you have a patent for making the super soaker specifically, different pieces, for example, the trigger mechanism, for example, the pump, different pieces that go into the super soaker may be patented by someone else. And in that case, if you go ahead and assemble the super soaker, you may be infringing on someone else's patent. So the right to exclude that comes with the patent right is different from the right to make. And when you are involved in making of something like a vehicle, well, you don't know which parts are patented by which automotive company unless you conducted what is called a clearance search. So you would like to conduct a clearance search if you're trying to make the product and make sure you're not infringing on someone else's patent. And you may conduct what is called a patentability search to determine whether you can obtain a patent or not. So these are different rights and different things that you may need to do as entrepreneurs. The right to exclude and the right to make. Now, let's go into patents just a little bit more. So, continuing on the line of what is a patent, there are three different types of patents: utility patent, design patent, and plant patent. What's the difference? The utility patent generally protects technology with a function. Utility, function. So any type of articles of manufacture, useful process, machine, composition of matter, as you can see here, the four different types of patentable subject matter. These all fall under a utility patent. And just imagine if what you have invented has a function, then you may likely file a utility patent to protect that product. And the term for utility patent is 20 years from filing. It is by far the most common of patent types, as 90% of patents are utility patents. I think we're around the 11 to 12 million mark at the time of this webinar. Next, design patents. You may have heard of design patents or the patent wars between Apple and Samsung, and those involve designed patents. For example, the design of the iPhone. They say that a picture is worth 1 million words, while these pictures are worth $1 billion. The design patent, and it protects ornamental design. Ornamental design embodied or applied to in an article of manufacture. The term is 15 years from grant. There are some nuances when it comes to design patents. The picture is of the utmost importance. What you see is what you have for the right of a design patent. That is contrasted with the utility patent, where the rights are nested within something called the claims, and we'll discuss that in a little bit. Well, these are design patents. Plant patent, it protects a new and distinct invented or discovered asexually reproduced plants, right? Such as mutants, hybrids, newly found seedlings, things like that for plant patent. And the term is 20 years from filing. I believe I've heard the story of the everyday rose, the roses that you see that is everywhere near Valentine's Day that is coming up. Those were indeed subject to a plant patent. Okay? So these are the three different types of patents. And I want you to focus on my words now. There are three different types of patents, but there are more different types of patent applications. Application is the paperwork that you file in order to obtain a patent. And there are different types of patent applications. Especially important is for utility patents. You may submit either a provisional application or a non-provisional application. This is very important for entrepreneurs. You may imagine the provisional application to be kind of like a bookmark. And you are essentially saying, hi, USPTO, I have an invention. I don't have the funds to hire a lawyer and draft a full application right now. Instead, I'm going to put everything about this invention into a provisional application, file it at the USPTO so that I have an early filing date. And then I will come back within 12 months and mature the provisional application into a non-provisional application. This 1 year, 12-month deadline cannot be changed, so be very careful. We did work with inventors who unfortunately had their provisional application expire, and that hurts. That hurts as a practitioner, right? So you have your provisional application, then you convert this into a non-provisional application. The non-provisional application is the one that is examined by the examiner, so that is the application that may become a patent, whereas a non-provisional application is not examined by the examiner. Okay? All right. Now let's chat a little bit about patent prosecution. And this is the process. In trademark application, we have filing, negotiation at the USPTO, and allowance and abandonment. This is essentially the same process for patents. You have invented, created an invention, then you decide what type of application to file, what type of patent you want to go for. It could be design patent, utility, plant. Right? And then you prepare and file the application. After it's been examined by the examiner at USPTO, they will often issue what is called an office action, which we discussed as a part of the trademark prosecution section. And you may send in a response. And this negotiation process goes on and on. I have seen applications go through 6 years. It can be a while. And the examiner may decide to issue the patent, so that you will obtain the patent. You may appeal the examiner's decision, or you may choose to abandon. And while this application is going on, you may actually file other applications related to the same invention, but different aspects of the invention. So that is the patent prosecution process, similar to in trademark, but often a lot longer. And let's discuss this patent. I don't know if many of you have seen a patent, and I always want to be the first one to show people what a patent looks like. And this is a sample patent. We come back again to the Super Soaker and the inventor of the Super Soaker, Mr. Lonnie G. Johnson. an absolute idol who has created my childhood here. Mr. Johnson is known for the Super Soaker, the Nerf gun, holds over 100 patents, and this is the Super Soaker patent. And let's dissect it a little bit so you know the makeup of a patent. And it goes on for a little bit. It's slightly long. It's a thumping good read for some attorneys, of course, and for some engineers, for plenty of solo inventors as well. So let's dive in. A patent includes the title for the Super Soaker. When it started, it was called the squirt gun. An abstract, which is a description of the invention, most likely the most readable portion of the patent itself. Drawings in order to further describe the invention. The specification, which is the long-winded discussion of the invention, and the claims. The claim is arguably the most important part of your patent because it lists out your legal boundary, the rights that you have. It is so important that it's subject to a quotable. The name of the game is the claim. And I hope that you can all recite that in your mind. Remember, knowing your rights is important. That means knowing what is in the claim for your patent. Now, we have dissected and reviewed a sample patent. You see the different sections. And it is definitely up to you and the drafting attorney to determine what is going inside that patent. So let's take a look at some of the key issues related to the patent prosecution process. Some issues that you might face when speaking with an examiner: invention versus idea, patentable subject matter, novelty, and obviousness. So let's dive right in. First, invention versus idea. You can obtain a patent for an invention, but not an idea. An idea is a little bit, has very low amount of details. If you're thinking about, I have an idea of having projectile water into my friend's face, and I say, excellent. How are you doing it? What's the specific way you are doing this? So unless someone else can exactly replicate how your product works, it is an idea and not a patentable invention. So when you're seeking to patent your product, that product must provide a solution that is definite and permanent, and the product is complete and operative. All right. So make sure that you have an invention, not necessarily an idea. 2, a patentable subject matter. There are things that simply are not allowed to be patented. For example, laws of nature, E equals MC squared, not patentable. Natural phenomena such as DNA, not patentable. And third, abstract ideas. For example, we all know the game of bingo. If you've gone on a cruise ship, that is certainly one of the biggest games out there. If you simply adapt bingo into a computerized version of bingo, that is merely trying to patent an abstract idea. So the game of bingo is an abstract idea that cannot be patented. So if you are creating a software application, it is important for you to discuss with the attorney whether your invention is patentable or not. Okay? Now, Novelty and obviousness. This is a little bit obvious. If someone has already done or produced an identical product, for example, if you have the super soaker patent and someone else wants to simply create the super soaker, someone else cannot then go ahead and obtain another patent for an invention because that patent lacks novelty. It already exists. So you may need to conduct a patentability search to determine whether the product already exists, whether you can even patent that product. Next, if your invention is obvious in view of existing products, if you want to create a larger super soaker, well, is your product patentable? Because someone would say, this is an obvious variation or an obvious change over an existing super soaker product. And this analysis is a little bit more difficult because what is obvious, right? What is obvious? So you might want to discuss with an attorney who is well versed in that technology and in that sector. What is obvious? So these are the key considerations that you may have when facing a patent examiner. But of course, there are other considerations as well. For example, the cost of patent prosecution, right? The financial costs. It could be, and this is an approximation of just filing, just the filing and drafting could be $7,000 to $15,000, and then add on prosecution, which would be another amount. So the cost of obtaining a patent is tremendous. So you need to weigh the business option. What is the pro of having a patent, and what is the con? The con being the cost. And the cost isn't just the financial. The cost is time as well. The average amount of time that the USPTO can get back to you is about 18 months. And that's the first time that you're hearing back from the USPTO. That is not including the negotiation. And the average amount of time that a patent would take is about 30 months. At 30 months, you would either receive an allowance or you would give up, right? This is the life of patent prosecution could go up and down. So this is also a cost of time that you as an entrepreneur need to understand. And of course, everyone wishes to obtain a patent if it's right for them. We talked about a lot of costs involved. We talked about the cost, money cost, time cost, but there is help for under-resourced inventors. For example, the pro bono program in different states. Idaho Patent pro bono, California Inventors Assistance Program, and New York. Obviously, we have a huge number of volunteer organizations. And of course, there's law school clinics, such as our law school clinic at Cardozo School of Law. And I run the Patent Diversity Project here, where we focus specifically on underrepresented inventors. And we provide patentability analysis and searches, draft provisional and non-provisional applications, provide general patent IP consultation, and we certainly look at trademark issues as well here at the Patent Diversity Project and the Tech Startup Clinic. And I hope I have given you a little bit of information on intellectual property, specifically patent and trademark. I have teed up some big ticket items, but they're certainly not all-encompassing. A 1-hour webinar is not going to do it. So I invite you to ask any questions and have any comments. I would ask Victoria to assist me if there are any questions I would be happy to answer them.
I don't see any questions in the chat right now. I'll give people a couple seconds if you want to, think about a question you might have for Victor. Okay. Well, if we don't have any questions, I would really just like to thank you, Victor, for being so informative tonight and serving as a guest lecturer for the IP for the People webinar series provided by the Institute for Intellectual Property and Social Justice. I know I've definitely learned something new today, and I really hope that everyone in the audience did too. Fortunately, this was all recorded, and we'll be sharing this on our YouTube page at a later date. We'll be sending an email out to everyone once that's uploaded. We also hope that you'll subscribe to our newsletter so that you can be informed of future events, including the next sessions of this webinar series. So thank you to our wonderful speaker and to everyone who participated tonight, and I hope you all have a wonderful evening.
This meeting is being recorded.